Drake sí declarará en el juicio de X, pero no de la manera regular, de ir a la corte y hablar delante del jurado, ya que han estado saliendo muchísimas noticias de que él no va a declarar, y eso no es que sea correcto del todo, porque sí lo hará, pero de cierto modo restringido, es decir, responderá unas pocas preguntas y todo esto vía una videollamada de Zoom el 24 de febrero. Hoy vamos a ver cómo el abogado de Drake, el hombre de aquí, va a defender a su cliente y cuál es la razón real por la que Drake no se quiere presentar. Te recuerdo que el día 6 ya está subido, que es el testimonio del chico que le pilló la foto de X y parecía que había consumido algo, que incluso más tarde fue el que difundió las fotos de X después de perder la vida. Este es el día 5 y lo subo después del 6 porque justo el día de después confirmaron vía documentos legales que finalmente Drake hará una videollamada respondiendo solo a unas pocas preguntas. En el día 7 hablaremos de las novias que han ido a testificar, al igual que la chica a la que le alquilaron el coche. El día 8 tenemos nuevas evidencias que se encontraron, como el casco de bala en la casa de Dedrick Williams, que es el que le faltaba la máscara para cometer el crimen. También hay nuevas imágenes, como por ejemplo la chaqueta de X que estaba tirada en el suelo, y muchísimas cosas más que descubrirás en los siguientes días. No me enrollo mucho más. Si no has visto todos los días previos, te lo recomiendo muchísimo porque se te va a hacer mucho más fácil entender todo esto. Tienes la lista completa en los comentarios o por aquí arriba. Gracias por todo el amor y vamos para adentro.
Hey, lo mío saben que me importó, respeto por todas la base que parto, bendiciones hasta el que se me viró, esto gracias a Dios por el don que me dio, todos saben que yo, soy el que comandó, desde cero subió, y nadie lo bajó, soy el líder, yo soy el jefe.
The actual order itself, Judge, doesn't give any reference to what the penalties would be if Mr. Graham failed to show for that deposition. I don't even think we need to get there. I think that the affidavits attached to the motion are insufficient. I don't believe that an order to show cause is appropriate given the lack of foundation in the petition. There's not only missing pages, but the things that are attached to it, the affidavits that were filed.
Por cierto, cuando se vaya a referir todo el rato a este muchacho como Graham, ese es el nombre real de Drake. Por si decís quién es Graham, es Drake.
In order to show cause. So, I don't think we need to get to the point where I would argue that even the service itself didn't go down the way that it was stated that it went down. I don't think we need to get into an evidentiary issue at this point, because I don't think the affidavits rise to the level of an order to show cause. And then if an affidavit if a subpoena for deposition is going to be reissued, then upon that reissuance and that possible service, then we would have an argument as to the harassing nature of it. Because at this point, I think you have a cooperating witness that corroborates that Mr. Graham has nothing to do with this case. Mr. Graham is not listed in any report. Mr. Graham, I don't...
Vas a escuchar a lo largo de todo esto cómo él va a defender a Drake y cómo él no tiene que ver, cómo Drake supuestamente no tiene que ver nada en todo este caso, ya que también vamos a ver previamente, voy a hacer una pequeña interrupción, un vídeo en el que básicamente Robert Allen, uno de los acusados que estaba presentes en todo este crimen, como él no conoce ni a Drake, ni a DJ Academics, ni a Skimas de Slum Code, que justo lo tengo aquí.
You even know Drake? Okay. Personally or otherwise, or even middle people?
Ahí le acaban de preguntar si conoce a Drake personalmente. Bueno, primero han preguntado si lo conoce y él ha dicho que personalmente no lo conoce.
You know anybody in Toronto? Do you know any of the names like Slump Guy or DJ Academics or any of those names?
DJ Academics y el famoso amigo de 6ix9ine, básicamente una persona pues que comunica toda la información acerca de raperos y tal por redes, y Skimas pues el mejor amigo de X, ¿verdad?
Did anybody connected with Drake that you're aware of hire you to do the crime of being a victim on June 18, 2018? How about Mr. Boatwright? Did anybody connected with Drake hire Mr. Boatwright to do this crime? No. How about Mr. Newsom? Did anybody connected with Drake hire Mr. Newsom to do this crime? No. How about Mr. Williams? Did anybody hire Mr. Williams by Drake's team to do this crime?
Lo dicho, están haciendo muchísimo hincapié con el tema de Drake, están siendo muy constantes y súper pesados para sacarle toda la información posible. Incluso lo dicho, en el día 5 han hecho tanta presión a Robert Allen, incluso se ha puesto nervioso, se ha equivocado en ciertas cosas, ha dicho una cosa, después ha dicho la otra, por lo que están metiendo mucha caña con el tema de Drake.
Discussed whatsoever in this case, to my knowledge, other than rumor and innuendo, and I believe that it's, if I was hired earlier, I would have probably filed a motion to quash that deposition itself, because like I said, there needs to be some good faith showing. At least, you know, his phone was in the area, he was in the state of Florida at the time, there's some sort of communication, there's something, and there was absolutely no evidence whatsoever other than rumor and innuendo. And the problem is that...
Pero que Drake estaba en Florida por esos tiempos, yo eso no lo sabía. También no lo he dicho en el último vídeo, pero parece ser que justo Drake y X, previamente a estos sucesos, estaban ya bien. Habían tenido su beef y tal, pero parece ser que ya se llevaban bien y que habían dejado el beef atrás.
Elvis made me do it. You can't go then take Elvis's depot. Well, you can't anyways, but I'm just giving you an example. That doesn't rise to the level of now I get to take someone's depot because this individual said, you know, someone made me do it. So I don't think we need to get to that point, Judge. I think prior to getting there, I don't think the affidavit's attached.
No sé cuántas veces ha dicho ya, we don't have to get to that point. Es este tío, es que no quiere que Drake se presente ahí. Aparte que causaría también muchísimo drama, en plan, las redes estarían ardiendo si Drake se tiene que presentar de verdad. Yo te digo que se va a liar gorda.
That level, I pointed out the inconsistencies in those affidavits, especially the inconsistency in the affidavit from Mr. Padilla's secretary, who says there's some subpoena dated January 19th. There is no subpoena attached dated January 19th. There is a notice, but that notice isn't even in the court file. That is a notice that was never filed. I looked online, there's no notice ever filed for that January 19th. And then the last point, and I don't even know if I need to address this, is that when you submit a subpoena and you serve someone with a subpoena, that subpoena needs to be accurate as to time, place, and what I'm going to be questioning you. You can't say, hey, and the subpoena, well, the notice itself is a little strange, but I'll address that in a second. You can't say, hey, contact my office, I'll give you a Zoom link. It's like, hey, I want your deposition. I'm not going to tell you where it's going to be. It's going to be somewhere in the state, somewhere in the county. You contact my office, I'll give you the address. There's no law that puts an onus on a deponent to contact an attorney, either the state or defense, and puts that burden on them to contact us, and we'll tell you where it is when we can. I understand the security aspect. There's ways around that. Number one is you don't have to file the subpoena that you actually serve on the individual. You can just file the notice. That subpoena can be filed under seal if you want to file it. So those are two different ways. The third way is Zoom provides a password. You could provide the Zoom link and then say, we will email you a password. There's a million different ways to do it. It wasn't done here. No fault. I'm not faulting Mr. Padilla. I think Mr. Padilla was trying to do what he thought was proper for the Zoom link. And I've had cases with Mr. Padilla before in the past. I think he's a good attorney. I think he knows what he's doing. But in this case, I just don't think it's appropriate. I don't think the order to show cause is appropriate because of what I laid out before, Your Honor.
Ahí está nuevamente diciendo de que él no quiere de que Drake se muestre en el juicio.
If we did have the actual subpoena, even if we had the actual subpoena, I don't think the subpoena would have been valid because of that Zoom link. And I do want to just put on the record, Judge, where it says in the notice, which again is dated January 19th, it says Zoom details to be provided separately via email. That's the first statement. Then under that it says contact Padilla Law Group for details. Even that's confusing. So are they providing the link in an email that's going to be emailed to me and then I'll know what the link is? Or do I need to contact the office? And again, that's in the notice. It's not even, I don't even know if that's in the actual subpoena. So for all those reasons, Judge, I'm asking that the order to show cause be set aside. And then if Mr. Padilla wants to serve a future deposition, if and when that future deposition is actually served, I'll file my motion based on that, but I don't think it's right until that point.
Judge, really, when wondering who Drake would hire, literally the most popular celebrity in the world, I figured here comes Brad Cohen. And even the finest attorney that money can buy will not undo what this court justly did. And I understand his arguments, but Judge, this case, and I agree with him that I wish he would have been involved earlier because he would have been privy to the arguments that we had when we laid out the reasons that Drake was involved and the motion to perpetuate testimony that this court didn't allow. However, the court did allow for his deposition to be taken, and the court alerted all parties to treat it with the same scrutiny that you would at trial in case he wouldn't be able to attend trial.
Por cierto, este abogado, que es uno de los abogados de los acusados, está, vamos, súper seguro que Drake tiene algo que ver, porque este fue el que sacó el tema de Drake y el que pidió que los detectives revisaran todos los detalles, que revisaran todo a la perfección para ver si Drake estaba conectado, y ahora nuevamente saca el tema de Drake y este tío él mismo quiere que Drake se presente sí o sí.
Arguments that he made, I believe, are insufficient. This was domesticated in California. There was an affidavit from the attorney that did it. It's very clear that when he says that Mr. Graham isn't involved in this case, it's very clear that Cleopatra Bernard thought so when asked in deposition, why did you have security with your son that day? Because of Drake and Migos.
Esto también es verdad, esto lo comenté en el vídeo de X y Drake. X también tuvo movidas con Migos serias, pero serias, Y la madre justo quería seguridad respecto al tema de Drake y el de Migos. Y X también en su momento estaba de acuerdo con tener seguridad por esas situaciones, porque delante de un hotel cuando X salió, habían tortazos, se lió gorda, os lo digo en serio.
And it's very clear that the decedent predicted if anybody, it's Drake. So I understand his arguments, and I understand he's an extremely skilled attorney. However, the court ruled the way that it did for a reason, and I believe that the court's ruling should stay as it is.
El tío ha dicho tal y como está, él quiere que venga Drake.
I don't think he addressed any of again, I think the affidavits speak for themselves and that they're insufficient, Judge. I don't even see a subpoena attached to the order to show cause from either.
Él dice como que no hay suficientes pruebas, como que Drake se ve envuelto, como que para que haya esa necesidad para que se presente.
More from Florida, so I don't even think we can base an order to show cause on a quote-unquote notice that we don't know if that notice was served, and certainly we can imagine that it wasn't because that notice is dated 2 days after the alleged service. So the notice is dated 2 days after the alleged service. The affidavit makes reference to some subpoena from January 19th, 2 days after the alleged service. All these things, they don't rise to the level of an order to show cause. In fact, I think that quite the opposite is that I don't even think the service was effectuated properly with the information that's attached to that motion.
All right, so a lot of different things raised here. First of all,
ahí va el juez, a ver qué dice. Al fin y al cabo él es la persona que decide si Drake viene o no.
From the beginning, the court expressed some reservations, I suppose, about whether or not this is a witness that should be deposed. However, we felt that the defense raised at least, through what he said, this is a first case. Defendants are facing potentially life in Florida State Prison.
Eso es verdad para las personas que no saben qué pena pueden recibir. Habían personas que estaban diciendo de que deberían de recibir la pena, pero lo máximo que podrían recibir es pasar el resto de su vida detrás de rejas.
What is necessary for rule to show cause, see, the arguments you're making here are like what I would hear at a rule to show cause. Why shouldn't you be held in contempt? Wasn't properly served, all these things. So these are defenses, good defenses, apparently, potentially, to a rule to show cause. The issuance of the rule to show cause is not my order telling him go to a depot. It's my order saying, defense trying to take a depot, they're presenting me with evidence claiming proper service. 2 times prior to this, whether you're aware or not, that they had asked for this, and I said, this isn't even close to proper service, and it was denied. On this attempt, I said, I think it's close enough where the person did not respond. I want to know why. That's the whole idea behind the show cause, not that you are in contempt, but tell me why you weren't there. What's wrong with it? Why wouldn't you?
Básicamente parece ser que este tío no se presentó 2 días antes porque resulta que no era tan importante como decían. De todos modos, ha dicho que los argumentos por parte del abogado de Drake son bastante buenos. Aún así, a ver qué dice ahora, porque a saber qué comentarios nos dice acerca de que si Drake si se tiene que presentar o no.
That's the purpose behind the show cause. Now, always in the show cause, we put in a purge order saying, look, if you're from the thing, I don't even need to get involved in that. As to whether or not you have an excuse or no excuse or good reason or not a good reason for not appearing. So, let's understand that from the first area why the show cause is there is merely not whether or not this subpoena should or shouldn't be quashed, or whether it's valid, whether it stretches the limit of discovery, but you got served and you didn't come, court wants to know why, all right? So, that's what's behind that order. Now, without getting into the issues that you have raised and not having an entire evidentiary on that, you need to discuss with your client how you wish to proceed on these things, because again, just like the first couple of attempts, the court said, no, these are not near, what would be required. This one appeared to be. There may be some defects in it. At some point, if they continue to try, they may effectuate good service.
He may. Just not yet, but I get it.
So what I'm saying is, we can quash this now and then, at some...
El juez está pidiendo cómo avanzamos con este tema exactamente si él no quiere que Drake aparezca.
Taking a statement or moving to quash a subpoena as if it has been properly served for whatever reasons, we might have to have an evidentiary on that. My thought is this: in order to assure the due process rights of the defendant and the full discovery, to make sure that every avenue has been explored and nothing's been left untouched, my thought is that if your client were to have this video, or this, not video, but Zoom, electronic.
Claro, él está diciendo, en vez de que aparezca como físicamente en persona, de que se haga como una videollamada o algo.
You could certainly limit the scope and area of it. I am prepared to enter an order that, because I'm well aware that there is a lot of people who are titillated by, look who's involved in the gossip and the rumors, and everyone just wants to run wild with these things. I'm prepared to say that such discovery depositions shall remain sealed, and that the court would have an opportunity for an in-camera inspection of any transcript, and that it is not to be released to the public, not to be out there. There shouldn't be pictures of Drake testifying in the thing. I can understand why he's not interested in that. It shouldn't be. It should be right?
Eso es lo que está comentando, es justo lo que no quiere Drake. Drake no quiere aparecer en 20.000 titulares de Drake testifica su parte en el juicio de X. Es justo lo que él no quiere aparecer ni se quiere ver envuelto en esto. Aún así, desde que han dicho y ha dicho ya el juez en su momento de que Drake debería de aparecer de por sí, han habido 20.000 titulares. Yo lo he visto por todos los lados. Entonces imagínate, bueno, ya con todos los titulares y todos los artículos que hay respecto a eso, incluso Drake ahora mismo, incluso creo que está en tendencias. Drake ahora mismo está en tendencias. Justo estamos hablando de ello, Drake en tendencias. Lo que quiero decir con esto es que en caso de que se presente, se va a liar la de Dios. Por eso está el abogado de Drake buscando como otras opciones.
Cases that date back, I think, to 1985, including Palm Beach newspaper versus Burke at 471 Southern 2nd, 571, and Post Newsweek stations, Florida versus State at 474 Southern 2nd, 344, that say the public doesn't have a right to go to discovery depositions, and these are not public record unless they're entered into the court file. And so to ensure your client doesn't suffer from having this all over the place and having to answer the questions and then it's scrutinized by the public, I'm willing to keep that under wraps unless after looking at it, I see that it meets some threshold where this would become evidence in the case. So I'm certainly, I will put that out there, and this could potentially be a very short and quick deposition. What do you know about this? Nothing. Did you do this? No. Thank you very much. I don't know how much further it may go than that.
Esas son las preguntas que básicamente dice el juez que se va a hacer. ¿Has estado envuelto en esto? ¿Sabes esto? ¿Sabes lo otro? No, sí, no, y ya está. O sea que no van a haber muchas palabras acerca de que si no se va a hablar mucho, van a ser 4 o 5 palabras y ya está. Él no quiere que cuente toda la historia ni se va a hacer como ese testimonio súper largo como han hecho por ejemplo con Robert Allen o por ejemplo como en el día 6 que ya lo veremos más adelante de los trabajadores en River Motorsports.
I don't know what his questions are. I don't know what else he has. You understand what I'm saying?
Yes, but let me address two things, Judge. One is, I appreciate the court's indulgence in limiting the scope of any deposition that may or may not take place. That's the first thing that I wanted to address. I appreciate that. The second thing, Judge, is that I still believe, and I'm not even getting to the fact that the service was bad. I'm addressing the order to show cause itself and what it was entered based on. Order to show causes need to be based on the actual subpoena itself, right? The actual California subpoena itself, the service that is effectuated properly, okay, and a CNA that this individual did not show up to that deposition. What's attached to that motion, Judge, is number one, an affidavit that is not an appropriate affidavit. It is making reference to a subpoena that was signed on January 19th. I'm not even talking about the service itself. Let's assume the service was good, okay? If we assume the service is good, we don't have a CNA. We have an affidavit that says that there was a subpoena dated January 19th of 2023. We have a notice that's dated January 19th of 2023. And we have an affidavit from the individual in California that doesn't address whether or not there was other attempts made at service before this individual, JJ, was served, I don't know, the thing was left in a mailbox from some random individual who was named JJ on an intercom. So I think the first step we need to do here, Judge, in my opinion, is setting aside that order to show cause, reissuing a subpoena for that same day. It can still be February 27th, and serving the individual. I'll still address things with Mr. Padilla, I'll still talk to Mr. Padilla, but in order to effectuate a proper record, in order to effectuate a issue where we are issue free, there needs to be an order to show cause based on a proper affidavit that is not attached to this motion. There's not even a subpoena attached to that motion. So in order to get an order to show cause in the past, and I've been denied, surprisingly, because I do great work, but I've been denied orders to show cause where my affidavit was insufficient. And in this case, there is no way around that this affidavit is insufficient, where it's making reference to a subpoena that is not attached, nor is it part of the record, dated January 19th. And then the California affidavit talking about, you know, what...
Básicamente lo que está comentando todo ese abogado por parte de Drake es que está poniendo ejemplos de que sigue sin haber la necesidad de que Drake aparezca. Tened en cuenta de que ese es el punto base y a partir de ahí va a intentar doblarlo de cualquier manera. Falta de evidencia, no hay necesidad, no está relacionado, no se conocen, etc.
Those affidavits, just looking at those affidavits on their face, are insufficient. In fact, the proof of service is 2 of 2. We don't even have page 1. I don't even know what's on page 1. And the court doesn't have it. And it's not listed anywhere in the court file. So, when I boil this all down, I'm agreeing with Your Honor in terms of limiting scope, in terms of talking to Mr. Padilla. And I'll talk to Mr. Padilla. Mr. Padilla and I have talked before on other cases. We'll talk on this case. But I think the first step is setting aside that order to show cause. Any way you cut it, he's still going to have to serve Mr. Graham again, or serve him the first time is my argument, because I don't think that was good service. But any way you cut it, he's going to have to serve. And with an order to show cause, it's even a higher standard, where that order to show cause should actually say what the penalties are, and then Mr. Padilla would have to effectuate personal service on him in order for the order to show cause to take place. You can't effectuate substitute service for an order to show cause. So,
él está pidiendo que haya como un proceso previo antes de que en todo caso Drake tenga que aparecer, ya sea presentar pruebas, de que se comunique ciertas cosas antes y demás. O sea, lo dicho, el tío va a evitar de que Drake aparezca sí o sí, va a hacer todo lo posible, a ver si después lo consigue. Su propuesta, ojo,
You already granted the motion for him to take the deposition in terms of serving Mr. Graham. Serve Mr. Graham for the February, I think it's a February date. What date is that? February 25th or whatever it is.
25. En la inscripción pone 24,
We'll address it. But the problem is that if you look at this record and what was filed and what's in the court file, Judge, it doesn't rise to that level of an order to show cause. And the order to show cause itself doesn't list what the penalties are for not showing. And normally an order to show cause is this. An order to show cause says, and you've done plenty of orders to show cause in the past, and when you were in private practice. An order to show cause says, you must appear before the court on XYZ date. If you don't appear on XYZ date, this is what's going to happen, XYZ. In order to avoid that, the purge is this other thing. This order to show cause doesn't say that. So not only is the order to show cause as facially deficient, it's based on affidavits that are facially deficient. So my argument is this, and like I said, Judge, I'll address if he's re-subpoenaed, if he's reissued a subpoena, if he's actually served proper service. I'll address all that, and I'm going to talk to Mr. Padilla before that, because it could be maybe I can file an affidavit with Mr. Padilla saying, you know, we don't know anything about it, but knowing Mr. Padilla, that's probably not going to be enough.
Por cierto, Padilla pues es el otro abogado.
The affidavits are not valid, so set aside the order to show cause. Let Mr. Graham get, if we can effectuate service on Mr. Graham for a deposition, and when that service is met, I will call Mr. Padilla. I'm telling you as an officer of the court, I've never misled anybody in any courtroom, in any county or any nation, in any state. I will call Mr. Padilla upon that effectuating.
Le va a pegar un toque a Padilla
and work something out with Mr. Padilla. But the order to show cause cannot be entered based on...
Claro, él dice de que el Padilla es el abogado de parte de los acusados, uno de los acusados. Y le está diciendo, yo quiero que Drake venga, yo quiero que Drake venga. Y el juez ha dicho, oye, ¿para qué quieres que venga? Y él ha dicho, pues para la información, para escuchar lo que dice. Que yo creo que lo quiere atraer simplemente para intentar sacar, pues, de cierta manera, pues información, que es comprensible. Pero el abogado por parte de Drake está diciendo, oye, si quieres información, te la paso por privado, privado, lo hacemos todo en privado, pero no que salga al público, que es pues por parte lo que este abogado quiere evitar que suceda.
Even the dates are incorrect. So, if we're going to enter an order to show cause, I understand the argument I can make at an order to show cause. But these aren't even arguments to be made in an order to show cause. These affidavits, the order to show cause shouldn't even be entered, is what my argument is. The arguments to be made at the order to show cause are, this guy who showed up and buzzed on the buzzer and said, oh, who's there? There's a guy named JJ, and he says, okay, I'm going to accept service, which there would be testimony that this is not how it went down, but the affidavit is, I'm here to serve Mr. Graham with a deposition. Will you accept service? And some random guy named JJ on an intercom says, yes, I will accept service. Please put it in the mailbox at the end of the driveway. Makes little to no sense, but that would be my argument at the order to show cause. My argument here is that these affidavits that were filed are insufficient to even enter.
No hay suficiente información nuevamente, no hay
I'm
suficientes
asking for you to
archivos.
set aside that order to show cause. It is of no consequence to Mr. Padilla if that gets set aside, because he's going to have to serve this anyways. He's going to have to serve it for a deposition. So let him serve it for a deposition. If and when that service is effectuated, I will call and I'll work something out with Mr. Padilla to figure out what we're going to do.
Ahí está ofreciendo la oportunidad de arreglarlo en privado con Padilla en vez de sacarlo todo a la luz.
If the service is good. That's my proposal, Judge. And I'm sure Mr.
Yo no veo al juez bastante convencido, la verdad. El tío también no.
Padilla, knowing Mr. Padilla, he doesn't like that. But that's my proposal.
Esa es su propuesta.
The one thing that he hasn't said is that he will accept service for Mr. Graham, because he will not. And if the affidavits were insufficient, and if it wasn't enough, this court would have never executed that order. And I understand his arguments, but they're just trying to prevent my client's due process rights to move forward with the deposition. And I appreciate the court saying that it's going to narrowly tailor the issues discussed, and that's it. I don't understand, he keeps reiterating if this court would have never executed that order if it didn't have it.
All right, well, I have something.
Ahí se está calentando la cosilla,
He will camp out at that game when JJ walks out there. He'll say he's over it. If he still even works there.
Mysterious JJ.
But the bottom line of the thing is, if we're going to make this happen, let's make this happen. Let's do it at a time that is the most convenient to your client. Let's schedule,
Ojo.
that time again. The time that's most convenient. Counsel's available, everybody's available to do it, and like I said, I don't intend for this to be used to harass your client in any way, and for that purpose, rest assured that I'm not going to allow this to be splashed all over and look at Greg answering questions and that sort of thing, because that's not the purpose behind this. So I can give you that, and,
yes, sir.
And he can effectuate his
Service.
diligence to have fully investigated for his client. And I mean, in the end, if your client feels that this is all done just in bad faith, well, then he's got a remedy for abuse of process, and that's a whole other realm. That's two stages beyond this.
We will discuss.
Bueno, conclusión. En principio, Drake no se tendrá que presentar a no ser que el juez lo diga. Van a intentar mediarlo por su propia cuenta. A malas se hará una videollamada, como habrán dicho, por Zoom, por videollamada. Que seguramente una videollamada y que a la mejor hora que le venga a Drake, porque lo que quiere evitar el juez y el abogado de Drake es que la gente pues después saque sus títulos, todo el contenido en las redes sociales de que Drake ha respondido o Drake ha dado su testificación, su testimonio acerca del caso de X.